Hello everyone. Today let's learn about Article 21 of the Indian Constitution. Article 21 comes under Part 3 of the Indian Constitution, which is dealing with fundamental rights. Article 21 is known as the foundation stone of Part 3 of the Indian Constitution because Article 21 deals with protection of life and personal liberty. So without life and personal liberty, we cannot exercise any of other fundamental rights. That's why Article 21 is known as the foundation stone of Part 3 of the Indian Constitution. Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. That means through a valid procedure established by law, the life or personal liberty can be taken away. Article 21 begins with no person. The term person includes citizens as well as non-citizens. Thus, Article 21 is applicable to all persons, be it a foreigner or a citizen of the country. Now let's look into the important elements of Article 21. There are three important elements of Article 21. They are life, personal liberty, and the procedure established by law. Life is not a mere animal existence. It is something beyond that. Life includes all the bare necessities which are essential for a person to lead a dignified life. Thus, in order to lead a dignified life, we need food, shelter, livelihood, privacy, dignity, clean and healthy environment, pollution-free air, etc. So, what all things are essential for a person to lead a dignified life will be coming under the purview of life. The second important element of Article 21 is personal liberty. Liberty means the ultimate freedom, which means when there is liberty, then there cannot be any restrictions. So when a person is given liberty, he can do whatever he wants, there won't be any restrictions. When we live in a society, liberty cannot be granted to the people because when a person enjoys his liberty, he may interfere with the rights of others. Thus, in a society, liberty must be limited. So when liberty is limited, that becomes freedom. Freedom, unlike liberty, is subject to restrictions. That is why the right to freedom under Article 19 is subject to reasonable restrictions. Thus, through laws, restrictions can be imposed on these freedoms. But in the case of liberty, restrictions cannot be imposed. So, there are practical difficulties in adopting the term liberty under Article 21. And that is why, under Article 21, the term personal liberty is used instead of liberty. The term personal liberty refers to the liberty of the person or the liberty of the body of the individual. Thus, only when there is coercion or physical restraint upon the body of the person, we can say that there is violation of the personal liberty. In all other cases, when there is no coercion or physical restraint involved, then there is no violation of the personal liberty. The term personal liberty was interpreted in this way in the earlier cases. In A.K. Gopalan vs. State of Madras, the term personal liberty was interpreted as the absence of coercion or physical restraint. Thus, the scope of the term personal liberty was very limited. But in the case of Kara Singh vs. State of Uttar Pradesh, the scope of the term personal liberty was widened by the judiciary. The court held that personal liberty includes all kinds of freedoms other than those mentioned under Article 19 Clause 1. Because Article 19 Clause 1 specifically provides certain kinds of freedoms. Thus, the term personal liberty includes the residue of the freedoms contained in Article 19 Clause 1. So, in Kara Singh vs. State of Uttar Pradesh, the scope of personal liberty was widened to include all kinds of freedom other than those mentioned under Article 19 Clause 1. The term personal liberty was further widened by the judiciary in the case of R.C. Cooper vs. Union of India. In R.C. Cooper vs. Union of India, the court held that the overlapping of the term liberty in Article 19 Clause 1 and Article 21 does not limit the scope of personal liberty under Article 21. Thus, personal liberty cannot be interpreted as the residue of the freedoms contained in Article 19 Clause 1 alone. This was further reinstated in the case of Meena Gandhi vs. Union of India, where the court held that the term personal liberty includes a wide range of freedoms and not only the absence of coercion or physical restraint. Thus, the right to travel abroad will also come under the purview of personal liberty under Article 21. Now, talking about the third important element of Article 21, that is the procedure established by law. In A.K. Gopalan vs. State of Madras, it was held that the procedure established by law means the procedure which is made by the state or the executive. Thus, the protection of life and personal liberty is available only against the arbitrary executive action and not against the arbitrary legislative action. In ADM Jabalpur vs. Shivakant Shukla, it was held that Article 21 is the sole repository of life and personal liberty against illegal deprivation by the state. Thus, protection of life and personal liberty is available against the state or the executive. The term procedure established by the law is different from the due process of law because procedure established by law is available only against the arbitrary executive action while the due process of law is available both against the arbitrary executive action as well as the arbitrary legislative action. Procedure established by law is applicable to procedural laws like CPC, CRPC, etc. On the other hand, due process of law is applicable to substantive laws like IPC in addition to the procedural laws. In the Indian Constitution, there is the term procedure established by law. That is, Article 21 provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The American Constitution contains the term due process of law. There, no state shall deprive any person of his life, liberty, and property except according to the due process of law. In the case of procedure established by law, the judiciary will look whether there is a law and the procedure which are provided by the law are complied with or not. But in the case of a due process of law, the court will look whether the legislature has the power to make a law and whether the natural justice principles are complied with or not. The drafters of the Indian Constitution consciously provided the term procedure established by law under Article 21 instead of the due process of law. Because when due process of law clause is used, both the procedural as well as the substantive fairness must be complied with. Thus, while enacting laws, natural justice principles need to be complied with. That will create difficulties in enacting the socio-economic legislation. So, when procedure established by law is used, then the fairness of law need not be looked into. That's why the term procedure established by law is used under Article 21. Until the decision in Meena Gandhi versus Union of India in 1978, protection of life and personal liberty was available only against the arbitrary executive action. But in Meena Gandhi versus Union of India, the court developed the golden triangle concept, that is the interconnectedness of Article 14, 19 and 21. The court held that Article 21 does not exclude Article 19. Thus, when a law prescribes a procedure for depriving a person of his personal liberty, will have to meet the requirements of Article 19. Also, reasonableness is a golden thread through fundamental rights. The principle of reasonableness is an essential element of equality under Article 14. That must also apply equal force to the procedure. Hence, these three articles, that is Article 14, Article 19 and Article 21 are mutually inclusive and therefore the procedure must be just, fair and reasonable and not arbitrary, fanciful or oppressive. Thus, the procedural as well as the substantive fairness was upheld in this case. Thus now, there is no difference between due process of law and the procedure established by law. While talking about the right to life, there arose another one question as to the waiver of the right to life. The waiver of the right to life is the right to die or the right not to live. Whether a person is having the right to die under Article 21. In P. Radhanam vs. Union of India, it was held that the right to life includes the right to die. In that case, Section 309 of IPC was held as unconstitutional. Section 309 of IPC provides punishment for the offence of attempt to commit suicide. But this decision was overruled in the case of Gain Kaur vs. State of Punjab. The court held that the right to life under Article 21 does not include the waiver of that right, that is the right to die. Thus, Section 309 of IPC is not unconstitutional. Right to life is an enumerated right under Article 21. There are a lot of enumerated rights under various provisions of the Constitution, like the right to equality under Article 14, right to freedoms under Article 19, etc. What is an enumerated right? An enumerated right is a right which is explicitly provided under a particular provision. Unenumerated rights are those rights which are not explicitly provided under different provisions but implied under those provisions. Examples of such rights are right to be silent and right to internet under Article 19. Similarly, Article 21 provides a wide range of unenumerated rights, and those are right to livelihood, right to live with dignity, right to clean environment, right to pollution-free air, right to privacy, right to reputation, right to speedy trial, right against illegal detention, etc. The judiciary, by exercising their power of judicial review, recognized a number of unenumerated rights under Article 21. Thus, over a period of time, the judiciary played an activist role by giving the widest possible interpretation to the three important elements of Article 21, that is life, personal liberty, and the procedure established by law, and thus widened the scope of Article 21. With this, I would like to conclude this video. Thank you.